So today we're going to be talking about the common law system, and I'm going to be talking about the origins of common law. So before the Norman Conquest of 1066, England had no centralized legal system to decide cases based on common principles. Before the conquest, all your courts were local in nature and they used local customs to decide these cases. So the William I, the King of UK at the time, identified a need for a common law system in the country so that everyone can have the same law. It can be an opportunity for equality for everyone. Then came the Normans, where they put a feudal tax system, which was basically to collect revenue and resolve your minor disputes which might happen in collection of the revenue. After that, they eventually got into public litigation. So they established three very influential courts: the Exchequer Court, which dealt with financial matters, the Common Pleas Court, which dealt with property division and possession, and the King's Bench, which dealt with law and order situation and the peace of the country. Eventually, they got prominent to the point where the earlier local courts faded away from being the main courts of legal resolution. Now, the idea of common law here was the idea of royal delegation of justice. The principle here was that justice must flow from the king through the judges using the principles of common law. So, the adjective common came to describe the law common to the entire territory of England.
So, this system was born in England and it was spread across various countries in different continents. A select few men traveled the length and breadth of UK and applied these legal principles to all kinds of disputes. Rulings in previous cases also gave rise to the system of precedents. British Empire was at its peak, as a result of which these legal principles were either adopted or imposed on these colonies, even after their independence. There's a common saying that the sun never set on the British Empire is particularly apt to explain the importance of Britishers in the colonial rule as well as common law to the Commonwealth. Through their conquest, USA, Canada, and India adopted a lot of common law. Now let's take an example. The English legal system has a concept of forms of action or writs, and our Indian constitution has adopted these 5 of these writs, and they play an integral part of our legal system. These 5 writs are habeas corpus, mandamus, prohibition, quo warranto, and certiorari.
Let's talk about the common law's features, the main tenets of it. So the common law has two main things: the principle of casuistry, which is the method of deciding cases, and the adversarial system. So the principle of casuistry is where the law moves from one case to another. And when a large number of cases have been decided on a particular point of law, a principle emerges out of it, which becomes a judicial precedent. Now, the common law system is inherently casuistic, as it relies both on case-based reasoning and judicial precedents to resolve disputes. Another key aspect of the common law system is that it uses analogical reasoning. So, judges would often draw analogies between the case at hand and past cases, identifying similarities and understanding the differences to know how they should guide the decisions based on the individual circumstances of the case. One more thing about this legal reasoning is that it's very flexible and it's context sensitive, so that it's able to change in the dynamic times and the dynamic situations we live in today. The judges also aren't bound by rigid rules or propositions because they use situational logic. This also ties in well with the adversarial system, a hallmark of the common law jurisdictions. So the adversarial system is basically a legal process in which two opposing parties present their case to an impartial judge, and the judge bases his decision on the unique facts of the case, as well as keeping in mind the principles of casuistry while dealing with the realities of modern life.
Now that we have talked about the features and origins of common law, now let's see how India, a country based on regional laws and custom, came to be a common law country. So the Britishers came to India as a trading company through a royal charter and settled in factories. The main towns where they developed the factories were Madras, Calcutta, and Bombay, which came to be known as the Presidency towns. Then from 1765 to 1774, they claimed sovereignty in the country and established the Supreme Court in Calcutta. This court has the jurisdiction over employees of the company, and in some instances, it extended to the Indian citizens. Then from 1862 to 1865, the high courts were established in the presidency towns: the Bombay High Court, the Madras High Court, and the Calcutta High Court. These high courts had jurisdiction over a larger public. and they decided cases based on justice, equity, and good conscience, in where there was no particular directions from the English common law. These courts played a prominent role in bringing the common law to India. The main features which India took from the common law were adversarial system, the principle of casuistry, the rules of precedent, and the rule of law. To conclude, I would like to give the essence of what Mr. Bose said, that the English common law was migrated to India particularly by the British. It was administered by their judges, and that it has infiltrated deep into the laws of this country, and through some extent it has shaped its thoughts and customs.